Good morning.
Good morning.
All right,
Good
we're going to
morning.
start. All right, we're going to start momentarily. I'm just awaiting I have a few questions of the clerk's office with respect to exhibits and what have you. So just hold on 1 second and we'll commence the hearing.
Okay, and excuse all the noise. There's a gardener right outside our door.
Can't hear it at all.
Good.
Wow. You get it?
Yep.
The old style. You feel it? Yeah. I do. I didn't feel it, yeah. But I got it. Alert.
Just now?
Yeah, just now. 4.5.
I was feeling a record. Oh my gosh.
Okay, all right, folks. We're going to go ahead and
4.5
start.
earthquake. Makai, just so you know, we just had a small earthquake over here at 4.5, but we're all good.
4 point. Okay. Whoa.
Thank you, Mr. Ball. Yeah, get on the alert.
Okay, do we want to take a few minutes so folks can gather themselves, or is everybody okay?
I think we're all good now.
I'm exhilarated.
Okay.
Like a cold plunge.
All right. Good morning. It is 9:33, and I'd like to call this morning's hearing to order. Good morning. It's 9:33, and I'd like to call today's hearing to order. Today we have petitioner Emory Holdings LLC versus South Coast Air Quality Management District as a respondent. Mr. or Madam Clerk, are there any individuals online desirous of providing any evidentiary or non-evidentiary testimony?
None.
Okay, we have members of the hearing board that are remote. I'm remote. My address was posted pursuant to the old Brown Act way. There's no one here with me. Ms. Verdugo Peralta and Mr. Pierman are remote. In Temecula, are there any individuals or persons, groups, organizations with you today? You're muted.
Sorry, just Art Peralta.
Okay, and your agenda was posted pursuant to the old Brown Act way.
Yes.
Okay, fair enough. All right, we have exhibits. Just for the record, the district did not submit any exhibits. No exhibits have been received from the district. The exhibits that we have before us, exhibit number 2, timeline of events. Exhibit number 3, email notifying AQMD of telephony and gas turbine commissioning. Exhibit number 4, AT&T is a California public utility. Exhibit number 5, Rule 2012-Chapter 7 RTU architecture. Exhibit number 6, AQMD missing data procedures for May through July. Exhibit number 7, SoCal gas meter / Cal ISO meter. Exhibit number 8, Cal ISO telemetry exemption request form. Those are all the exhibits that we have for NRE. Who's representing NRE today?
2 parties, the general manager, Albert Dietz.
Turn your microphone on, please.
Good morning, Mr. Chairman. There are 2 parties here before you. The general manager of the IceGen facility, Mr. Albert Dietz, and myself, Michael Munoz, the director of compliance.
And who's representing the respondent?
This is John Jones on behalf of the executive officer.
Okay, so before us today, the first matter that we'll take is the motion to quash deposition subpoena for production of business records. And what we'll do is we'll allow the petitioner to provide the open arguments relative to that matter. Then, of course, the respondent. Are there any individuals, Mr. Munoz or Mr. Jones, you would like, or Mr. Dietz, you would like to have affirmed vis-a-vis the oath of office? Or excuse me, the oath, the witness oath, rather.
Mr. Chairman, for the regular variance, the normal variance, we would like to swear in Mr. Lee and Mr. Ryan Maxwell, but I don't believe Mr. Maxwell is here.
Okay, so we'll go ahead and we'll just wait until the regular hearing and we'll go ahead and move forward with this matter. All right, opening arguments.
Chairman Ali, I have a question about this. I'm going to address each of Mr. Jones's points. Should I stop at the end of each of his points and allow him to rebut, or I go all the way through?
No, go all the way through.
Okay. Thank you, Board, Mr. Jones. In the motion to quash, Mr. Jones's first argument is that the subpoena is moot because he says that the district would not be opposed to granting relief similar to that in case 6257-1. We think this is a smokescreen. Mr. Jones is attempting to portray AQMD's actions as reasonable when they're not reasonable. And I'd like to go through the conditions of each of the components of the order in case 6257-1. In condition one, condition one is that the petitioner shall validate its zero emissions data points by verifying that no fuel is fed to the gas turbine device D1 by continuously monitoring fuel gas flow to D1 during the variance period. In the event that petitioner feeds gas to D1, then missing data procedures shall be followed. Our issue with this is that we are a Federal Energy Commission regulated public utility peaker plant, and this is the summer. Will most certainly be ordered by the California Independent Systems Operator to make electricity during this summer. So should we agree to this condition, we would immediately violate it on our first run order. Condition number two is the petitioner shall not remove the fuel gas meter from service. We find this objectionable because it's already a condition of our Title V permit. Condition three is the petitioner shall provide fuel flow meter readings monitoring gas turbine device number D1 within 24 hours upon request of the South Coast Air Quality Management District and within 24 hours after the communication system failure has been resolved via email to Air Quality Inspector Jennifer Wang. For no reason, the district has made this condition more restrictive than the actual Rule 212 subsection C3D, which allows for 48 hours. Condition 4 and 5, we have no issue with. Condition 6 is the petitioner shall pay all applicable fees, including excess emission fees, if applicable, to the clerk of the hearing board within 15 days of notification in writing that the fees, hearing board fees, subsection K. We won't agree to allow the district to calculate excess phantom emissions and be obligated to pay these false values without recourse. We will not give up our right to seek injunctive relief in federal court for the period of April through today. So the last point I would make on this statement of the subpoena is moot is Mr. Jones never sent me an offer to agree to or not to agree to. And I hope, as Mr. Pearman will back me up and say that if you don't have a meet and confer, you can't say that you were willing to negotiate a settlement. So we don't think that the subpoena is moot because they haven't offered a settlement. And if they did offer the same settlement, we would have objections to it because it's just not workable for our obligations under the Federal Energy Regulatory Commission tariff. The second point Mr. Jones brings up is that the subpoena is overly broad and unduly burdensome. And he says a broad request of roughly 30 years of data is a massive undertaking that would require retrieval from multiple archival systems, privilege review, and extensive redaction of sensitive financial and third-party information. Mr. Jones is a great guy. I don't think that he's trying to mislead the hearing board. I just don't think that he's aware of how important the financial implications of missing data procedures are to the district. Every year, the district commissions a reclaim audit report that includes Table 5-1. In Table 5-1, the district lists out the number of tons of phantom emissions created by missing data procedures. As part of the subpoena of a, as part of a separate legal action, INERI has the district's 2021 reclaim audit report from 1995 through 2021. Missing data procedures yielded $354,896,000 in 2025 RTC credit value. For the purposes of this subpoena, request number 1, INERI would be satisfied with reclaim audit reports for the years 2022 through 2024. That's 3 already created report and is hardly unduly burdensome. The third point Mr. Jones makes is that the requested information is irrelevant. And so I asked the board to consider 2 questions. What actions can INERI take to be in compliance with District Rule 212, given that AT&T is a public utility and we can't force them to restore our modem line? There are no actions that INERI can take. We're completely subject to AT&T's timeline. So why does AQMD oppose INERI's relief from Rule 212? Upon information and belief, it's because missing data procedures are money-making machine for AQMD. If the hearing board doesn't grant relief to INERI, we are looking at phantom MDP, missing data procedure fines of $2 million by the end of the year. The district's position is not offering a solution to the condition outside of the control of INERI is based on a profit motive. The district has the means and the motive to take property from INERI seemingly without recourse. Mr. Jones's next point is that the subpoena is outside of the hearing board's jurisdiction. Section 9-2 of the hearing board rules states, the subpoena may require such witness to produce all books, papers, documents in the possession or under the control of such witnesses which are material to the hearing. The reclaim audit report states, the 2021 reclaim audit report that I referred to previously states that it is important to note that portions of the annual emissions attributed to missing data procedures include actual emissions from the sources as well as the possibility of I'm going to read that again. It is important to note that portions of the annual emissions attributed to missing data procedures include actual emissions from the sources as well as the possibility of overstated emissions. MDP may significantly overestimate emissions from some of the sources that operate intermittently. These reports are material to the hearing in that INERI is a peaker plant. We don't run unless called on, and we run less than 92 days in a year and only 5 hours typically of each day. So the statement in the 2021 reclaim audit report that MDP may drastically overstate our emissions is correct for us. INERI is regulated by 24 local, state, and federal agencies to which we have to submit over 96 reports per year. Report formats include online portals, email databases, online entry, etc. AQMD is the only agency that uses a 1990 copper line with a floppy disk mechanism to import data. INERI is being penalized due to AQMD's use of this technology. Why is this antiquated technology being used is material to this hearing. The hearing was noticed to the public. The public has a right to know what happened to $365 million created by missing data procedures, much less the businesses who were forced to buy these NOx credits through MDP. Only the hearing board can answer whether it is material in knowing what will happen to the millions of dollars that the district seeks to take from INERI. Mr. Jones's next point is that the subpoena seeks privileged and confidential information. Reclaim audit reports are confidential, but they're not privileged. These records were subject to previous production and so should be produced now. Mr. Jones argues that determining where the money goes will likely fall under deliberative privilege. Will likely is not a legal argument for exclusion. If Mr. Jones feels a document is subject to privilege, he can list the document in a privilege log as is standard procedure. Making a blanket conclusionary statement is not a legitimate argument. Those are my responses to Mr. Jones' motion to quash. Thank you, Mr. Chairman.
Thank you, Mr. Jones.
Oh, is this on now? Okay. Thank you, Mr. Chair. Thank you, members of the board. I think we can take the gist of the argument is that Mr. Munoz really doesn't like the missing data procedures. He'd very much not like to have to deal with them. And even if we take him at his word, and I don't think we should, that is not something the hearing board can address. They can't get rid of the missing data procedures. If he wants to file an injunctive relief in federal court, he certainly has that right. But in terms of what the hearing board can do today, that is what the subpoena is supposed to be for. And what he needs to do is show 6 factors for the variance. None of the things in this subpoena are necessary to do that. Now, he mentioned during his argument that he'd be willing to take, fewer than the 30 years. Now he says he'll take 3 years worth. We could talk about 3 years, but that's not what was in the subpoena. What we got was a subpoena asking for everything, and so we had to respond to what we received. I don't have an issue with meeting and conferring about the 3 years. We probably can come to some agreement on that. So that point may be moot. I don't know that. We could probably just sidebar and do that. As for his second point, that the motive of the district is somehow to make millions of dollars, and the public has a right to know. Again, there are other forums for him to make these arguments. This isn't that one, but it also ignores the fact that Reclaim is, as the district has said, the goal is to sunset it eventually. So that's not really consonant with the idea that we're trying to make tons of money. If we were doing that, we wouldn't be in the process of coming up with ways to sunset the program. That doesn't simply make sense. And his final argument about, like we just do a privilege log, and so all of this is speculative, but the whole point of the motion to quash is so that we don't have to produce 30 years worth of data, go through all of that, spend all and then do the privilege log. That's not a response. The point is we need to deal with it on the front end. And so as to the specific question, is any of this necessary for him to get the relief he's seeking in his variance? And the answer to that is no, none of it is. It's certainly relevant toward his larger argument to paint the district in whatever light he'd like to paint, or to argue against missing data procedures. There are legislative avenues, there are other judicial fora he could go to. But in terms of what the hearing board can grant in terms of relief, it's simply not relevant to that. I would like to address the point about the meet and confer, which I find odd. Before the interim hearing, I gave him a series of the conditions that were in the prior case as a starting off point. Never heard back from him. So the idea that we never reached out, I don't know, isn't true. But I'm not saying that he has to have specifically the relief in the Harper case, but the point is that there is a way to get him to compliance with the rule that the hearing board can grant. And so that was meant as an example of what to do. It doesn't have to be exactly those terms. Some of them we can discuss. But as to what the board can do here today, we're not opposed to finding some avenue for Mr. Munoz to get relief today. That's not why we're here. We opposed at the last hearing because he didn't have a good cause. He had weeks and weeks of notice and didn't do anything about it. That's not good cause, as the board found. But good cause isn't an issue anymore. Now we're just dealing with the requirements of the 6 factors. We don't object to finding some collaborative way to get him there. And so since we're not opposing that, there's really no basis for going through all the effort here that he's asking for. It just isn't relevant to what we're trying to do here today. And it isn't relevant to what the board can actually accomplish. Again, the board, it's as I showed, the board lists very clearly on its website with the things it can and cannot do. And almost all of the things that Mr. Munoz has argued about are things the board can't do anything about. And so it's for those reasons that I don't think that any of the documents are relevant, and the motion to quash should be granted to the, if the board were to be inclined to grant summer leave, then we would ask that this be significantly pared down from the 30+ years worth of data that he's asking for. Because certainly we don't need the entirety from the Reclaim Act to present to address any of the issues that he's brought here today. And for those reasons, I think the motion should be granted. Thank you.
Thank you. Thank you, Mr. Pearman.
Sure. Thank you. Maybe you should turn. You're moving. Are you hearing an echo or can you hear me okay?
Yes, we're hearing a little echo.
We're in echo.
We've got two computers here. Let me see how I can change things. Why don't you?
I think if Miss Cynthia turns down her volume, then it won't hear Mr. Roberts speaking in that room.
Any
Cynthia,
better? Yeah.
mute, turn down the volume. Great.
Can you hear us now?
Great.
Yeah, it's better, Mr.
Can you hear us?
Yes, go right ahead.
Yeah.
Okay.
Yeah.
So, I looked at the petition and it didn't raise these issues of bad faith, money-making motivation, etc., that have been addressed as the points in the requested subpoena. The 3 points raised on the surface are not relevant to the petition, which is why we're here today. And after hearing the oral argument, it seems that conclusion remains, that it's just not relevant. As indicated by the district, our job is to enforce the rules, protect the public. If a business is found to have violated rules or is a polluter, we have to act. Even if district modifications are some part and parcel of that, that can be dealt with presumably in some other fashion. We still can't ignore a rule violation on that basis alone. Also, we don't have the power, as indicated in the district papers, to investigate the district in terms of whether its rules make sense or to force them to revise them. Again, not our job, and particularly not our job vis-a-vis the setting of this petition. The request is, under any measure, way, way overbroad. And on that basis alone, there'd be no reason for us to have to reduce it. It's just so overbroad, it should be stricken on that basis as well. The district's raised an argument which seems relevant, that at least part of the documentation sought would be confidential and privileged. And as stated, based upon even the agreement in oral statements by Mr. Munoz, since they do agree to some of the proposed conditions that the district might accept, to some extent, there is a mootness argument here as well. And so even if you conclude there's some sliver of benefit, in the best case, some relevant documents, I think that pales in comparison to the detriment of unduly delaying the hearing today so we can address the admitted rules violation. So on that basis, Chair, I would strongly urge my board members to grant the district's motion in full.
Members of the hearing board, Ms. Verdugo Peralta. Floor is yours, ma'am.
Thank you, Mr. Chair. You have to lower your volume. Okay. My question is AT&T aware of all of this that's going on? Is there a rep that from AT&T that is aware of this? And the question is to the people from Enery.
Each time we call the AT&T hotline for government service modem, which is what we use, we receive a different operator, and they only reference the ticket number. So they are aware that we have a modem that doesn't have service. They're aware that it's a government service modem. Beyond that, they don't afford us any information as to what their priorities are.
Well, let me suggest this. They have an area manager, and they also have what they call commercial reps that handle business accounts only. They are not the people who answer the phone. And those two individuals are the people that you need to get a hold of. But I agree with Mr. Pearman in reference to his comments about this. So what I'm telling you is over and above the subject. I just want you to know that you have that ability to let them know what situation you are in. I recognize the fact that you're a peaker plant and that you probably will be called upon during the summertime when the demand reaches a level and they're looking for peaker plants to deploy, not necessarily yours, but whoever that they can get in touch with and whoever is the cleanest entity. But that being said, is not relevant right now. So I'm just wanting you to understand, because I come from the utility industry, so, and have worked with AT&T. So those are the two levels you need to contact, not just calling in and talking to a phone rep that's going to reference the previous call. You need to go way above that. Thank you.
Any additional comments from members of the board?
Mr. Chair, I do have
Yes.
a few questions before I make the comments of Mr. Munoz. Just wanted, Mr. Munoz, you're aware that we have a regular variance scheduled today, correct?
I do.
And it's not retroactive, whatever decisions made, it's moving forward.
I understand.
Okay. And so I have a hard time wrapping myself in your request, your subpoena, how that's relevant to today's hearing. And even if the board were to grant some portions of your request, you're looking at potential weeks or months before all the data is submitted to delay this hearing. Also, you're aware of that? That could be the case.
I am aware of that.
Okay. All right. So, all right. In that case, thank you for the responses. So, I too do not find I support the district motion to quash the subpoena. I do not find the request relevant to the hearing that we have scheduled before us. Whatever issues you have with missing data and how the district is making money is not relevant to the hearing that we have. We have to make the 6 findings to grant or deny the hearing. I don't see that relevant, to that procedure that we have to go through. And then you're looking at 30 years of civil penalty data, that's not relevant. The request for correspondence with other agencies, that's also not relevant. Request of the system, antiquated system, as you mentioned, is also not relevant in the sense that other reclaim facilities are using that same system to report emissions. So while you're in a unique position right now because of the theft and the inability to transmit the data, while you have the data, it's the request you have made, I don't find is relevant for the hearing we have scheduled for today. You can get this information you want through the public information request. You can go through a separate route and get all that, maybe portions of it. But I don't think we should delay this hearing anymore by, looking for some of this information that you need, which you can get through another avenue. So for this reason, I do support quashing the subpoena.
Thank you.
Any additional comments? All right, is there a motion laid upon the table?
Yeah, I'll make a motion that the district's motion to quash the business records subpoena be granted and the subpoena be quashed in its entirety.
Is there a
I'll second
second?
that.
Moved by
One second.
Moved by Pearman, second by Mr. Balaka Palan. Any further question or discussion on that motion? Hearing none. Dr. Abraham.
Aye.
Ms. Verdugo Peralta.
Aye.
Mr. Balaka Palan.
Aye.
Mr. Pearman.
Aye.
Ali votes in the affirmative. The matter is hereby approved unanimously. We're moving swiftly to the hearing. Do we want to go ahead and administer the witness oath? All individuals who will assume the oath, please stand and raise your right hand. Do you affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth? All right, let the record reflect that all have accepted the oath. Thank you. Mr. Dietz and or Munoz, the floor is yours for your opening arguments.
Morning, Chairman Ali and respected members of the board. My name is Albert Dietz. I'm the General Manager of Energy Ice Gen Power Plant. I'm here today to respectfully request a normal variance of Rule 212 subsection C3A, as Energy is interpreted to be in violation of said rule due to circumstances beyond the facility's control. Energy understands the importance of compliance and transparency in the process, and I want to ensure the board that we at Energy have made reasonable effort to resolve the transmission issues that have affected our facility. Understanding that the burden lies on the petitioner to be granted variance, I would like to present Chairman Ali and the board with several key points that will support the basis for our petition for variance. First point being that the petitioner for a variance is or will be in violation of section 41701 or any rule, regulation, or order of the district. Energy is in violation of the following rules. Rule 212, subsection C3A, install, maintain, and operate a reporting device to electronically report total daily mass emissions of NOx and daily status codes to the district central NOx station for each major NOx source. Such data shall be reported by 5:00 p.m. of the following day. There's no way we can do this. If our transmission lines are down, there's no way we can meet this criteria. Rule 212, subsection D2B, install, maintain, and operate a modem or any reporting device approved by the executive officer to report total monthly mass emissions of NOx to the central district station for each large NOx source. Once again, we simply cannot do this as we don't have any way to transmit this information. Rule 212, subsection E2B, report quarterly mass emissions of NOx to the district central station 30 days after the end of each of the first 3 quarters and 60 days after the last quarter of the compliance year for each process using a modem. For the third time on this issue, we just simply can't transmit these quantities or qualities to you. I'd like you to look at Exhibit 2. This would be the timeline that we've gone through with multiple entities, starting with our outage completion date of 4/1/25. When we came out of outage, we found that our T1 line was offline and our RTU modem was offline. RTU modem, Semtech, and internal troubleshooting. So at first we thought maybe this is the issue on our end. Maybe it's something we can resolve internally. So we did our due diligence, contacted AT&T and found that there was a theft of copper line underground, which that wasn't apparent right away. So there are a couple of days gap here, but the key points are on 4/2/25, the RTU modem, Semtech, and internal troubleshooting started. So we got in touch with Semtech, tried to fix our own modem, thinking it was an inside issue. Quickly realized that it wasn't on the same day. Contacted AT&T and discovered that there was an outage, and they created ticket PG49S831. We were told that there would be a field dispatch. Field dispatch ended up being more than the field technician could handle due to the archaic system, and they were more familiar with fiber optic lines, didn't really understand how the modem system worked, which is, I would like to say, most people my age and below do not know how dial-up routers work. I remember coming into the control room and hearing the modem for the first time, and it sounded familiar to me, but I didn't know from where. And I didn't say anything at first, and then it finally hit me that I remember that sound from when I was a child at my house. And I haven't since heard a dial-up modem until coming to California. But regardless, so emails from IceGen to the AQMD of our inability to transmit were on 4/10/2025. AT&T inbound call, AT&T inbound call. I'm not going to go through each of these transactions because it would just be exhausting, but there is a multitude of inbound and outgoing calls to AT&T trying to resolve this issue.
I'd like to jump in here and address Ms. Verdugo Peralta's suggestion that we escalate our troubleshooting beyond the operator. And I want to assure you, Ms. Verdugo Peralta, we've done that. We have a special designation for our modem line. We're a government service line, and we have access to government service technicians. But as Mr. Dietz has indicated, those technicians aren't familiar and do not have prints or materials for a modem line. So it's not that we haven't escalated the issue. It's that AT&T hasn't had the ability to restore it yet. Thank you.
Thank you, Mike. So if we work our way down this timeline, you just continue to see the inbound and outgoing calls. Even on the days where there weren't phone calls, people would check online on the ticket and see if there was any progress on the ticket. So if you don't see, and also we have at this point, we're relying on AT&T to correct the issue because they're a public utility. So to think that this would progress to this point now at that stage is just ridiculous that we would have waited so long to get a resolution to this problem that we would never thought at the beginning of it would have taken so long, because we have faith in the public utilities as we are one. So continuing down. Let's get back to the next point. All right. Yeah, we've all been down this line of how many times we've talked to AT&T, I guess. All right, so the next point for basis is that due to the conditions beyond the reasonable control of the petitioner, requiring compliance would result in either an arbitrary or unreasonable taking of property, the practical closing and elimination of a lawful business. So AT&T is a public utility not controlled by NRE. If you'll see Exhibit 4, it has some interesting points in it. So this is the Public Utilities Code, PUC. So AT&T falls under a public utility. And I think the most relevant point to this exhibit is carrier of last resort, COLR. And this kind of sums up AT&T's views on the underground copper old modem lines. AT&T is requested to be relieved of its carrier of last resort obligations in certain areas of California. If approved, AT&T California landline service separate from cellular, so this is just the landlines, like our modem, would no longer be required to offer landline telephone services where it is currently required to offer basic services in those areas. Basic services include 9 service elements such as lifeline rates for eligible customers, free access to 911, telephone relay service, and director of operation service. More information on basic. All right, so it gives you a link there. But what this is saying is AT&T doesn't want to deal with these problems anymore for land-based lines. And maybe, I can't speak for them, but maybe that's why we have such an ongoing issue with them that is unresolved. And that point brings it to, why are we still dealing with these outdated, antiquated systems? Why are we still using a dial-up router and a modem to try to transfer critical data that could cost us millions of dollars of phantom emissions prices? It's unreasonable to just have that one sole source. All right. So also, Entity cannot control AQMD's exclusive use of modem to transmit pollutants data. It's out of our hands. There's one way to submit this. We can't fix the problem. I'm not so sure if it's even our problem at this point. I don't see how this isn't a 2-lane road. This is your problem as well as it is our problem. And the fact that it's in between us. If you met us halfway, where would we meet? We would meet right at the break in this line where thieves have come in and disrupted the service. And there's no alternative method to reporting any of this data except for that line. AQMD's seeking to take millions of dollars from our corporation through capricious phantom MDP emissions. So if you'll look at Exhibit 5, or old Exhibit 5, new Exhibit 6, this is what it looks like for our company. In the 3 months, we will have accrued over $1 million in expenses for emissions from a plant that clearly has not run at all. Only on the days that we've acknowledged and we've been transparent with the AQMD that we were going to run. If you look at page 2, that's all phantom emissions. If you look at page 3, that's all phantom emissions. Page 4, all phantom emissions. This is a huge penalty to provide to somebody for something that is out of their control. For something that, as I see it personally, could be as much to blame on the other end. AQMD seeks to use the highest emissions hour in the last 365 days for every hour of every day, regardless of whether we ran the plant or not. I don't see how this seems fair when there are other means to determine whether we have run the plant or not. If you'll look at old Exhibit 6, now Exhibit 7, this is Southern California Gas Company's Measurement Collection Systems Gas Volume Detailed Report. As I'm sure the board understands, we only have one natural gas fed or a consumable engine at the plant. So there's no inside gas, there's no other way for the gas to go through our plant and be consumed except through our gas turbine generator. If you'll look at these, there are 0 MMBTUs on day 1, starting on 1/1/2025. And you can just follow it through page by page. The only days that we have where we used any MMBTUs is when we tried to test the facility and we let everyone be aware that we were going to do testing. We've been completely transparent like that. We're not trying to sneak power onto the grid for free. So without any consumption of natural gas, there can be no emissions from our gas turbine. There can be no emissions from the plant.
I'd like to jump in here and say that our Title V permit requires that we have a gas meter, a gas flow fuel meter, and that data that comes from the gas flow fuel meter is recorded in our AQMD approved continuous emission monitoring system. And that data is stored within that system indefinitely. So AQMD can access that information. But if a secondary method of confirming that we weren't creating emissions was necessary, the SoCal gas meter is a third-party verification source. And that's the point. We're showing zero emissions, but we're being charged MDP emissions for the highest value that we've created in the last 365 days. Thank you.
All right, so if you continue on with the Exhibit 7, you'll just see a continued, it's just, if you go through this whole breakdown of monthly MMBTU gas collection system volume detail report, you'll see that we haven't run the plant. I think this is pretty much conclusive evidence that there were no emissions being created because we weren't running the plant. So on to my next basis. That the closing or taking would be without a corresponding benefit in reducing air contaminants. Our plant is clean. Energy does not, nor has it ever created excessive emissions. MDP are phantom emissions not based on generation of electricity. As you saw in Exhibit 6, SoCal Gas shows no gas usage. Cal ISO shows no power generation created emissions. So that was also in Exhibit 7. So this is Cal ISO showing that there's no power generation. Without emissions, you can't have power at our plant. We do emit when we make power. So these two companies are respected in the community. SoCal Gas and Cal ISO are both reliable sources that prove in these documents that we haven't caused any emissions during this period, except for the ones that we have let you know about. On to the next point, that the applicant for the variance is giving consideration to curtailing operations of the source in lieu of obtaining a variance. Energy is not creating excessive emissions, or on most days emissions at all. We're a peaker plant. Exhibit 6, AQMD seeks to impose MDP penalties based on phantom emissions because Energy cannot transfer data due to an AT&T outage. So we don't run the plant all the time. We can prove that we haven't been running the plant, and we're still going to incur millions of dollars of MDP penalties based on emissions that aren't even there. During the period the variance is in effect, that the applicant will reduce excess emissions to maximize extent feasibility. Once again, we have never created excess emissions. Energy is a public utility and is subject to dispatch orders from the Cal ISO. IceGen will run when ordered to under federal law. If we get called to run, we have an obligation to the federal government to run the plant. During the period of variance is in effect, that applicant will monitor or otherwise quantify emissions levels from the source, if requested to do so by the district, and report these emissions levels to the district pursuant to a schedule established by the district. Energy continues to operate its SIM system. Our SIM system hasn't been down. Recording emissions data for every minute of every day. All data is being stored in an AQMD approved database, so the information is there. AQMD has refused to provide an alternate method of data transfer to modem, even though Rule 212, Chapter 7 shows the use of a floppy disk. So it's almost wild to think that there is something in here that says we could use a floppy disk, even though we've been told that that's not even an option now. It has to be reported through the RTU. I don't think many people at our facility would know what a floppy disk looks like. I believe that's all I have for right now.
Thank you, Mr. Jones. Floor is yours, sir.
Thank you, Mr. Chairman, members of the board. I'll try to be brief, but I will acknowledge to Mr. Deesa, yes, modems are certainly an old technology. I'm part of the before times who actually used those once upon a time, so I can appreciate that. And it's certainly the same for floppy disks. So and we can talk about maybe ways to improve that for sure. To begin, that he's in violation of the rule, I don't think is in question. So the first element's met, we don't object to that. With respect to being beyond his reasonable control, I mean, we have some questions there, but in general, certainly the copper theft was done. But although we have all kinds of information about times they've called the customer service line, we don't have evidence of efforts to go to that level above that or to seek other types of relief. Or even alternatives such as, would a relay work? We know other entities have been able to produce data. I don't know if they're on AT&T's network or not, but I mean, there's not much evidence of specifics in those to that extent. I mean, excuse me, with respect to those kinds of alternatives. But in general, with respect to the main argument about the theft of the copper line, there's certainly no, obviously that was done. And AT&T is dragging his feet, and it may even have some liability to Mr. Munoz at this point. I don't know. But so that point, I think we can talk a bit more about, but in general, we don't really object to closing it without being a corresponding benefit. There, things get interesting. Almost the entirety of the opening argument is, again, kind of an argument against missing data procedures, coming up, well, here's an alternative we could use, and this is be better than the current missing data procedures. And the problem with that, apart from the fact that the hearing board can't grant any relief related to it, is that the missing data procedures are part of a larger project. There's the EPA was involved. We have a state implementation plan that was involved. I mean, these procedures were developed over a long period of time and aren't something that we can just ignore. They are there. So if he's in violation, he does have to use them. And with respect to coming up with alternatives, the Harbor case, which he was a little dismissive of, I mean, Mr. Munoz is a little dismissive of, deals with just that situation where if you're not producing anything, you shouldn't have to use them. And it has a procedure within it to accomplish that goal. And the reason we didn't submit proposed orders because we thought that was really where we should start as a base. And since we weren't able to stipulate, we think if relief is going to be granted, it would make more sense to start there and work our way forward. But that complaint, I think, can be otherwise addressed with. But in terms of corresponding benefits, the AQMD certainly isn't trying to shut people down. That's not our goal. It's not the district's goal. And it is true that he's a peaker plan, although he made himself available. So there's that piece of it. But once he can certainly make himself unavailable, we're not asking him to do that. With respect to the next standard, the consideration to curtailing operations, I think, is kind of dovetailed to, well, we're not asking him to shut down. I think what's the benefit during peak season of him being shut down, and the corresponding benefit, I think, to the extent if he can run cleanly, we'd rather him run cleanly. During the period the variance is in effect, will he reduce excess emissions? I think, again, has already been addressed. And during the period, will he monitor or otherwise quantify? Again, this is him going back to the, excuse me, Mr. Munoz, Mr. D is going back to the missing data procedures, setting that aside. I don't think it's at all unreasonable to require him to agree to that, and certainly he would have to in order to get a variance in any event. So with respect to the documents on the paper, I think he's made enough to at least be credible to make a discussion. We aren't opposed to finding some solution here. Our goal isn't to keep him shut down or anything like that. And so in fact, we would invite a dialogue to that extent. But with respect to the overall argument, we don't have, the executive officer does not have any major objections. And in fact, if the board were inclined to grant relief, the executive officer would not oppose it. Within limits, of course.
Thank you. Mr. Dietz, your first witness.
Mr. Chairman Ali, we only brought Mr. Lee here to stipulate to or corroborate Mr. Dietz's testimony that the IceGen facility only has one consumption of natural gas, which is the D19 gas turbine. I don't know if that's even an issue for Mr. Balagopalan, which it was in our previous encounter. So other than that, we don't have any other witnesses.
Okay, so you don't. Okay, well, I mean, would you like to question Mr. Dietz any further? Because I want to turn it over to Mr. Jones so he can put his witness up. He has one.
I'd like to address questions to Mr. Jones.
Well,
Not appropriate.
well, Mr. Jones is not testifying. Mr. Jones is not a witness. Mr. Jones will put his witness up, and perhaps you can then cross-examine his witness. But Mr. Jones has not been, he's not been affirmed to provide witness testimony, and he probably won't.
Excuse me, Chairman Ali, I misspoke. It's not that I want to question Mr. Jones. I want to respond to some of the comments that he made about the district's position reference finding 3 and 4.
Okay, so is that considered, did you assume the oath of office, the oath of witness oath?
I did.
Okay, then go right ahead. Now understand, he's going to be able to examine you, and members of the hearing board will be able to examine you as well.
I look forward to it.
Very well.
Mr. Jones indicated that Inari was dismissive of the Harbor case. If I gave that impression, I apologize. That's not our goal. We're seeking a solution. We just haven't been provided an opportunity for a solution. I dispute Mr. Jones' timeline prior to the previous hearing, in that he sent us over a set of conditions, but that's in the past. Prior to this hearing, we didn't receive an offer for a stipulation. We're happy to enter into a discussion about that. I only addressed the Harbor stipulation as part of the subpoena. And I listed out the issues that wouldn't work for us, specifically number 1, because we know that we're going to be ordered to generate electricity. And so we will immediately go back to, under those conditions, the situation which we're in now, which is we're using missing data procedures for the day after we fire. So I'm happy to consider anything, and maybe we should take this offline for a break and do that, and not waste the hearing board's time if AQMD executive office is interested in solving the problem and not just kicking it down the road. I'm happy to do that.
So why don't we do this? Mr. Jones has already stated that he is more than amenable, as well as the district, to an amicable solution. So your suggestion is apropos. Why don't we take a recess, you two confer, and then we come back and we proceed forward with the matter. Because our objective here is to find a solution. Mr. Jones, are you okay with that, sir?
More than okay.
How much time would you need, Mr. Jones, as well as Mr. Munoz?
Mr. Jones can simply say, I agree, and we could be done.
Okay, so how about we take 15 minutes?
Fine.
15 minutes, we're off the record. We'll come back at 15 minutes. Yep, doing right now.
Alberto?
Yeah, so we're back on the record. Okay, we're back on the record. The parties are asking for additional time, so we're gonna go ahead and give them 20 minutes. Give them 20 minutes to work this out. And we're gonna go back off the record. All right, we're back on the record. Hey, Mr. Munoz. Mr. Dietz.
Chairman Ali, Board, I won't speak for Mr. Jones, but it appears that Mr. Jones's position is that there's nothing that we can do other than use their modem system to transfer the data. There's no other method of transfer. And I think his position is that this board, the hearing board, doesn't have the ability to grant any sort of waiver to our reporting by 5 p.m. The two solutions that we talked about were, could we configure our SEM system that we purchase and maintain through the very reputable firm of Semtech to use a fiber optic modem. And Semtech, we got them on the call, and they said none of their South Coast Air Quality Management District or California customers uses a fiber optic modem, but they know that NRG does. And so the answer is maybe, but they don't know technically how they would do it or when they would do it. But we're going to pursue it nonetheless, but we don't have a timeline. And then the second solution would be, could Semtech act as Inari's agent, and because they have access to our data, our database, because they maintain our SEM system. So we could set up a second server in their Hatfield, Pennsylvania location, transfer the data to the second server, and potentially they would use a copper modem line from their location to transfer to the AQMD system. They said they're not configured to do that every day. They could potentially do it on a weekly basis, but Mr. Jones says that there's no deviation from the 5 o'clock deadline every day for transfer of the data. So those were the two potential solutions. And the reason that the harbor solution won't work for us is because it'll work for us until we are ordered to generate. And then the moment we're ordered to generate, then we're back into the same situation. So I'll turn it over to Mr. Jones and he can probably better explain the situation.
Mr. Jones.
I think that's largely accurate. There are, at least theoretically, alternative means to, or emulators, either by fiber optic, cellular, probably some other technologies, where you can essentially make the equivalent of an internet phone call to a modem and transmit data that way. Like I said, his client doesn't, Henry doesn't know of what the timeline would be for putting something like that in place. And I am too far removed from doing that myself to give you one personally. But at least it seems that, at least in theory, that could happen, but there's no timeline for that. And so then the question became, well, okay, while we pursue this, can you grant us like a pause on the missing data procedures? And that's where we run into the wall, so to speak, because if he runs, he's going to get hit with missing data procedures. If he doesn't run, we have relief he can easily grant it, or at least the board has relief they can easily grant it for when it's not running. The issue is when he runs and gets hit with the missing data. And I don't see a way around him getting hit with it if he does that. It is not, certainly there's nothing we want to have happen. It's just, I think that's the reality of the jurisdiction of the board. We're certainly not opposed to trying to work with them. The other question, sending things in batches, the system isn't really set up to do that, or at least I'm informed that the system isn't set up to take like a weekly batch like that. But some sort of relay might work. So we would probably need more time to come up with alternatives that might conceivably get there. But right now, I think that, Mr. Muir is right. We can't quite, we're close, but we just can't quite get over this last piece of it through no fault of anyone's, really. But that's where we are.
One thing that I'd like to add here that I didn't realize that Mr. Jones just said that the board potentially could help us with is, it's not the run hours that were so damaged by having missing data procedures used. It's the non-run hours. That's where, like, we, in a 24-hour period, if CAISO tells us to run, we might run 6 or 8 hours. But for those non-run hours, we're still getting charged our maximum annual emissions for each of those hours, which, adds up. But if Mr. Jones would agree to use missing data procedures for our run hours, it's not ideal, right? Instead of 18 pounds per hour, it's 30 pounds per hour. And then use the harbor solution for all of the non-run hours for a period of, say, 30 days while we run down this modem solution, that would be agreeable to us.
Mr. Chair, can I ask a few questions of?
Go right ahead, Mr. Bullock. I mean, I know that we're kind of sort of out of character here, but I really want us to find a way to solve this matter. So Bullock, the floor is yours.
Because I think a solution was presented by Mr. Jones, with the harbor cogeneration unit, and maybe I can go through those conditions and
Sure.
we go through that. Both Mr. Is it Lee? L-E? Your last name is, I'm sorry, I didn't get. D. No, D. How do you spell that?
Oh, my last name is spelled D-I-E-T-Z.
Yeah, E-D-D. Okay, all right. I'm sorry. So, Mr. Munoz, let's look at that condition.
Yes, sir.
Where is condition 1? So, condition 1 says basically, my understanding when I read that is, when you got 0, you shall validate the zero emission data by verifying no fuel is fed. Oh, I'm sorry. I'm looking at the harbor cogeneration condition and
6257-1 stipulation.
I think it's exhibit. I don't know. It's not marked as an exhibit, but it was part of the submittal from the district in the motion to quash. Included was the ex parte minute order case 2657-1 for harbor cogeneration, which was dated May 17, 2024, signed by Cynthia actually. No, it's not the minute. It's yeah, it is ex parte minute order. It says it was attached to the South Coast response motion to quash. Yeah, it's.
If I may, if you look at the declaration that I submitted, it's Exhibit A to that.
Oh, it does. Yeah. Okay, you got it? Okay, so, Mr. Munoz, if you look at condition number 1, validate the zero emission data verifying that no fuel is fed to the turbine continuously monitoring. So it only says that in the event you feed gas to D1, then missing data shall be followed. So that's exactly what you're asking, said you're willing to do, only in the event,
You're right, Mr. Balagopalan.
Okay, that's good. We can move on then.
Yeah.
Okay, that's good. And then you shall not remove the fuel meter from service, that you are willing to accept that. You provide, number 3 is provide fuel meter readings and so forth, which you are already doing from the gas company. You have that already as part of your exhibit, one of those exhibit. Notify the district within 24 hours, that you can easily do. Notify the clerk when is compliance achieved. And then I think the 6th point, which you, let me finish and then you can go back to is the excess emission fee, which you had some issues with. There will be no, my point, the only excess emission fee is not the missing data fee we're talking about. The excess emission fee is if let's say you allow 30 ppm and you go to 50 ppm under normal operation, that is considered excess. So my guess is there won't be any excess emission fees. So that's why it says if applicable. So you would not potentially have any excess emission fee if the system is operating properly.
With that definition, you're correct, and we would accept it.
Okay, so basically, these are the conditions that harbor cogeneration was provided with as a solution. And I think if both parties are agreeable, then we have a solution, basically, because Mr. Jones said they're willing to go with this.
Yes.
Yeah.
The only change that we would ask for is in condition 3, instead of the 24 hours that we use Rule 212C3D, hours of 48.
Let's see what they say. I did, okay, but before, I did have a question. Is when your timeline in the exhibit showed that the AT&T will have it resolved today. So what is the latest date?
I cannot wait to get back to the facility and find out what the update they're gonna give us, and I'm expecting that it's gonna be another extension.
No.
I can't say that I have much faith in AT&T at this point. So I'm leaning towards I would like to go back to the facility and see everything operational, obviously. That would be optimum.
And I'm not sure if Mr. Jones heard what he wanted to change on number 3 to 48 hours instead of 24 hours.
Okay, well, I think the district has a witness who I think could provide some information that the board would find useful. So I know it's a little out of order, but I would ask that we have him bring him on so he can do that. You can ask questions.
Okay, no problem. So, Ms. Verdugo Peralta, let us capture your question before we bring up the witness.
Just two quick questions to Enery. Do you know if there are any other peaker plants that are having a similar problem? That's one question. Second question is, have you contacted CalISO to notify them of
To
this?
answer question number 1, we don't know any other plants that are having a similar issue. We think we're the only plant within our geographic area until you get to the ocean. So we don't know the answer to that. The answer to your second question is Exhibit 8 shows our outage tickets that we have submitted from the 1st of April through last night with the CalISO, indicating that we have a T1 failure through the AT&T line that we report our telemetry with.
Have they responded to you?
Yes, they've granted our petition each time. We've done it every 2 weeks, and so it hasn't been an issue with them.
Okay, thank you.
Okay, we're gonna go ahead and allow Mr. Jones to call us witness.
Okay, the district would like to call Thomas Lee.
Yes. Yes,
Can you state and spell your name and then provide your title for the record?
sure. My name is Thomas Lee, spelled ThomasLee. I'm a supervising air quality inspector here at the compliance enforcement.
And are you, I'm sorry. So Mr. Lee, are you familiar with the Rule 2012 that is essentially the subject of today's hearing?
Yes, I am.
And are you familiar with the various conditions that were proposed in the Harbor Cogeneration Company case?
Yes, I am.
Okay, we would like to ask you a couple of questions with respect to those as they've come up. As when the members of the board is asked, I would like to point you to variance condition number 1, where it says petitioners shall validate its zero emission data points by verifying that no fuel is fed to the gas turbine, device number D as in David 1, by continuously monitoring fuel gas flow to D1, again, D as in David 1, during the variance period. In the event that the petitioner feeds gas to D1, then missing data procedures shall be followed. Can you provide an explanation of what that means and what would that mean for Enery?
Yes. So to speak, can I see that condition real quick? Is it, can you hear me? Thank you. So in order for in condition one, in order for a emission data point to be considered zero, this is in reference to Rule 2012 C2D, I believe, C2E, where it's discussing about the equipment being demonstrated to be non-operational. So the gas line has to be either disconnected or meet those requirements to do so. So I just wanted to raise that issue. For the Harbor Cogen situation, it's my understanding that the unit was shut down and not in operation. And that's why this condition was able to serve that facility. So there's a one caveat where the Harbor Cogen was shut down, the turbines were operating, and the SEMs were recording the data. And because the unit was demonstrated to be non-operational, these conditions could be applicable. But in in Energy's case, where the turbine will be in operation, that means you guys will the Energy will either have to demonstrate that unit is not operating, again, according to 2012 C3E. And that means the turbine, and my understanding is when ISO calls upon you to operate your turbines, you will have to. So does that mean that you will have to demonstrate non-operation every single time you're called up? That is just a concern.
So
I apologize. Sorry about that. Yeah.
how should we proceed?
Well, we have one more. With respect to condition 3, where it mentions the 24-hour, and Mr. Munoz has asked that that be 48 hours. Is that something that is consistent with the rule?
Again, that condition 3 is referring to the request of information for fuel flow meter readings, the monitoring gas turbine. So that is really to confirm or that is to ensure that we receive gas flow data to confirm the compliance with condition 1 to ensure that no gas is fed to the unit. And to extend it to the 48 hours, there's no issue with that, but I think that's a separate issue here.
Okay, no further questions.
Mr. Munoz, your witness, you can cross-examine the gentleman if you're so inclined.
I am inclined. Thank you, Chairman Ali. Mr. Lee, when you use the word non-operational, will you please tell me what that means?
Yes, just one second. So per Rule 2012, C2E, demonstrating a NOx source is non-operational and no emissions are generated. And these are the conditions. For a NOx source in which fuel combustion is the only source of the SEMS monitoring emissions, the facility permit holder of the SEMS shall meet one or more of the following conditions. And that being to disconnect the fuel lines to the NOx source and place blind flanges to prevent fuel flow. Number 2, to demonstrate there's no fuel flow to the NOx source based on a dedicated fuel flow meter that is quality assured to the manufacturer's recommendation. Provide one or more gas bills indicating zero fuel consumption. And lastly, demonstrating the NOx source is not operational based on a stack flow monitoring system certified according to Appendix A. So that, to answer your question, those would be considered non-operational.
So that I make sure that I understand it, C2E says disconnected fuel lines flanged, a fuel flow meter showing zero SCM pass-through, zero fuel, I'm sorry, what was the third one?
Provide one or more gas bills indicating zero fuel.
Provide one or more gas
bills. My apologies.
And stack readings showing zero NOx emissions?
Shows that the exhaust flow is less than the lowest quantifiable rate.
Okay, 0. And C2E says we have to fulfill how many?
How many what, I'm sorry?
How many of those conditions do we have to fulfill?
One or more.
Okay, so we can agree to meet we can't do number 1. We can do a fuel flow meter, which we again, under number 3, ask for 48 hours to communicate that data to you. We can show the same as our exhibit, the 0 fuel flow from Southern California Edison. And we can show stack readings of 0 from our continuous emission monitoring system. Thank you.
Thank you, Mr. Munoz. No further questions of the witness?
No, Chairman Ali, thank you.
Thank you, members of the hearing board.
Yes, Chair.
Mr. Balakapalan,
Lee.
your microphone, please.
Your microphone isn't working.
I'm sorry. Yes, Mr. Chair, I had a question for Mr. Lee.
Go right ahead, sir. The floor is yours.
Mr. Lee, so what you read, C3A, and I think what is one or more of the following. And so they're willing, so by demonstrating no fuel to the NOx based on the, they can demonstrate several of those. So that in your mind is acceptable then?
I apologize. Can I gather my thoughts just 1 second?
Sure.
The witness is asking for a brief recess to look at the regulations. If that's acceptable, maybe 5
Not a
minutes.
problem. How much time would you need?
10 minutes.
10 minutes.
We're off the record for 15 minutes.
right, the clerk is here.
All right, we're back on the record. Okay, Ms. Verdugo Prata, I see your hand is raised. Do you have a question?
Mr. Ali, before we get there, I had a question of.
It was from before.
The break to respond. So,
Mr. Balakapalan, the floor is yours, sir.
do you have an answer, Mr. Lee?
Apologize, could you repeat the question?
Oh, no, you heard Mr. Moon.
Oh, yes.
That they believe that one of the following, so they willing to do that. Is that acceptable to you as a condition?
It is contingent that they meet certain conditions. So thank you again for the recess. I was just trying to get my thoughts together and I was just a little flustered. But as long as, yes, that's fine. But the Rule 2012 has additional requirements if they're going to be going down that road. And that is established in Rule 2012 C2D. And what that rule states is, as long as they demonstrate that the unit is non-operational, as I described earlier, those four things, they can be, they will not be subject to the MDP for failing to submit those notifications to us, contingent that the facility maintains the SEMS to record zero data points, which doesn't seem to be a problem. And that has to run for a minimum of 4 hours before the NUC source shuts down. Secondly, they'll have to submit a report to us. That report must include the cause of the shutdown, the time the monitoring device became non-operational, the time or estimated time the monitoring device returned to normal operation, and maintenance performed or corrective preventive actions taken. And this has to be submitted within 96 hours.
Can you cite the section of the rule?
Absolutely, and that is Rule 2012 C2C.
C2C?
C2C triple I.
Triple I? Okay, all right.
Okay. Does someone else have a comment? All right. So it seems as if we're down to an agreement. Mr. Jones and Mr. Munoz, are we comfortable?
I have one question of Mr. Lee in terms of C2C triple I. In the report that you're stating, it indicates that we have to communicate the cause of the SEMS breakdown, but it's not broken down. And we're continuing to monitor. How do you propose, what is it that you propose we would have to say? That the telephone line's out?
If I said breakdown, my apologies, I meant shutdown of the SEMS. So the minimum, the cause of the shutdown.
So if we agree that the SEMS is in continuous operation as it has been, then this rule doesn't apply. Is that correct?
I don't understand the question.
So you indicated that there was a shutdown of the SEMS system. We would have to report a shutdown of the SEMS system. Is that correct? Is that my understanding correct? I don't have the rule in front of me here. I'm opening it up now.
I can read that portion if that's okay, Mr. Ali.
Go right ahead, sir. Go right ahead.
It's whenever the monitoring device is non-operational more than 24 hours, the facility holder shall submit a report to the executive officer within 96 hours after the device become non-operational. So in this situation, the monitoring device is operational. I think that, so it does not really pertain to what Mr. Lee was.
Correct. I just wanted to give you the whole
The whole picture.
the whole picture
Okay,
of-
but Mr. Munoz is right.
Thank you for that clarification.
then we would have no issue with that.
I do have a question, though. We do have to set a time frame for this variance. We probably need to get a status update, and I would propose another additional condition that both parties still work on alternative methods, that you mentioned too, Mr. Muniz, whichever is feasible, that during this time period, because we don't know how long this is going to be non-operational.
We completely agree with that.
So what kind of time frame are you requesting for this variance period?
90 days.
90 days?
Yes, sir.
Okay.
The district that's acceptable to the district.
Okay. So then another condition to that during this period that both parties will explore other alternative means of just leave it open and sort of shall explore other alternative means of transmitting data to the district.
Yes, well, we were happy to do so.
Okay. So is that acceptable, Mr. Muniz?
It is acceptable.
Okay.
Mr. Balagopalan, I want to make sure that in finding alternate solutions for communication, we stated two tasks that we're going to do. We're going to seek a fiber optic modem, and we're going to see if we can convince our vendor to act as our agent.
Right.
One of the other components that we would like to see from AQMD is in our Exhibit 8, the RTU RTU infrastructure architecture shows a database capability of importing data into that system. We would like to know whether that exists or in reality and what the mechanism is for using that. We'd like a commitment from the district.
So I'll leave that's why I suggest we leave it open-ended to explore all any option. So you get 3. If you come up with some other solution later, that's you can discuss with. I mean, both parties have to agree that it's feasible. That's all.
We agree.
All right. Why don't we move to closing? Mr. Munoz.
Thank you, Chairman Ali and members of the board and AQMD. I'm super happy that we were able to come to an agreement, and it's an amicable one that takes into the reality the situation where we just didn't have an alternative. So thank you. I think that this process worked as it was intended.
Mr. Jones.
The district concurs. We're happy that we were able to reach a consensual agreement with Mr. Munoz. He was open and we were able to reach that. And I think this will, at least in the short term, get us through what we need to do today. So if the board were to decide to grant Mr. Munoz relief, the executive officer would not oppose that.
Beautiful, beautiful. Members of the hearing board.
I'll go ahead and I'll make the 6 findings first before, and I can prefer the proposed. I'll make the motion to maybe the proposed conditions. So the 6 findings: the petitioner is in violation, as we saw, of 2012C3A. They are unable to transmit the data to the AQMD central station. That this non-compliance is beyond the reasonable control. As we heard, there was a theft, pillage, and the communication system is not working for them. The line, T1 line, and the copper line, whatever, it's all ripped out. So AT&T is hopefully working on it. So it's beyond the control. The harm to the petitioner overweighs the benefit to air quality, because they are a peaker plant, so when they don't operate, there are no emissions. When they do operate, they have SEMS that are monitoring those emissions and will say if they're exceeding the emission limit. So the harm to the petitioner overweighs the benefits to air quality in this case. They've given curtailment to give consideration curtail operation, so they will not operate unless they're called upon by CalISO. So that's basically it. And during the period, they will reduce excess emission to maximum extent possible, because they have and the existing SEMS will monitor that and will indicate. And the petitioner, the last will monitor and quantify emission levels. They have the SEMS, and they can monitor and quantify the emission level. So I do believe we can make the 6 findings to to grant the regular variance relief for a period of, say 90 days, so 90 days it is, you know. So I can, if there's no, I'll wait for the other board members if they have comments, and then I'll make the motion.
Any additional comments? Okay, why don't you go ahead and make the motion, Mr. Balakaplan?
Okay,
Ms. Verdugo Pralta, did you have any further comments to the?
I'm just very happy that after all of this, going back and forth and how it originally was acrimonious, that we have come to a very amicable conclusion and agreement between both parties. Because I do understand how they were between a rock and a hard place, and I'm glad that the AQMD is helping them communicate better. I'm hoping there's going to be some better technology down the road. So I'm happy with this whole thing.
All right, Mr. Balakaplan, the motion.
okay. In the matter of Henry Holdings LLC, case number 6248-3, I move that we grant regular variance commencing today and continuing through 90 days from the following rules of Rule 212C3A. It'll be October 29th. Okay, so the 90 days. Okay, through October 29th from the following Rule 212C3A, and for the equipment located at, and I was looking at the location. Let me see if I can find that.
17171 South Central Avenue,
As indicated by Mr. Munoz. What city is that?
Carson, California.
Carson, California. Thank you. For the conditions of the variance I have set forth, and I'm going to basically refer to the Harbor Cogen set of condition with the changes that I'm proposing, and I will, let me see where I just put that here. The conditions, the variance condition will be similar to case number 6257-1 for, and as listed in the expedited minute order with the following changes. Condition number 1 will be D19 is for D1. Condition number 3 shall be changed to, again, there's a D1 to D19, and within 48 hours, and then to the inspector will be, sorry, slow down, okay. The inspector's email will be, it's to you, which will be, can you cite your email for the record?
Yes, tlee2, TLEE, the number 2 at aqmd.gov.
Okay, and the condition number 4, again, will have the same email address, tlee2 at aqmd. Number 3. 48 hours, you know. Okay, and then so that's the 6th condition. The 7th condition, and may need some help here. Petitioner during the variance period shall explore other means to communicate. Shall explore other means to communicate data to the South Coast AQMD, working in conjunction with staff from AQMD, the district staff, you know.
Can you change the first word to petitioner and the district shall explore other methods?
Okay, yes, I'll restate it. Petitioner and the district shall explore other methods to transmit data to AQMD.
No, that's fine with the district.
That's fine, okay.
What is there a second?
Second.
Second.
Thank you. The motion has been moved by Mr. Balakaplan, seconded by Dr. Abraham. Any further question or discussion on that motion? Dr. Abraham, your vote?
Aye.
Ms. Verdugo Pralta?
Aye.
Mr. Balakaplan?
Aye.
Chairman?
Aye.
Ali votes in the affirmative. The matter is hereby approved unanimously. Thank everyone for their time today. We are officially off the record at 11:59 a.m. and adjourned.